they took upon themselves the constitutional responsibility of saying that we are now the legislature. We are the Constituent Assembly. And we will exercise the will of the people of state of Jammu and Kashmir to say that we abrogate 370. In essence, that's what happened. Is that possible constitutionally?
Yeah.
With regard to the fundamental rights, some basic principles agreed between the parties were enunciated. It was accepted that the people of the states were to have their fundamental rights. But in view of the peculiar position in which the state was placed, the whole chapter relating to fundamental rights of the Indian Constitution could not be made applicable to the state. The question which remained to be determined was whether the chapter on fundamental rights should form a part of the state constitution of the Constitution of India as applicable to the state. So it was not applied at that time fully. With regard to the jurisdiction, I'll leave that out on the Supreme Court. And then there was a great deal of discussion, item 8. With regard to the emergency powers, the Government of India insisted on the application of Article 352, empowering the President to proclaim a general emergency in the state. State government argued that in the exercise of its powers over defense, item 1 of the Union list, in the event of war or external aggression, the government would have full authority to take steps and proclaim emergency. But the state delegation was, however, averse to President exercising the power to proclaim a general emergency on account of internal disturbance, which ultimately your Lordship knows was also taken out of the Indian Constitution under 352.
At the relevant time, it was there.
It was there at the relevant time, but the state said we will not allow it to be exercised.
I'm just trying to think aloud. At the relevant time in 75.
Yes, it was there.
It was there.
It was very much there.
And this, through some subsequent orders, it equally applied to Jammu Kashmir at that time.
That's correct. That's correct. Absolutely right.
This summary, which my friend was doing, Delhi Agreement summary, this seems to have been taken out of this book note and Justice A.S. Anand.
It's not publicly available, but Justice Anand has that one.
Constitution, it's published. Constitution.
No. The agreement is not publicly available.
So he has given the authoritative statement in the sense, what is it? What does it imply?
That's correct. This is also part of the compilation, but it is before your
yes.
Justice
That's what we
Anand
were reading.
Yes. Then, brothers, in order to meet the viewpoint of the state delegation, Government of India agreed to the modification of 352 in its application to Kashmir by the addition of the following words, but in regard to internal disturbance of the request or with the concurrence of the government of the state. That's how. But the parties agreed that the application of 356, dealing with suspension of the state constitution, and 360, dealing with financial emergency, was not necessary. Then Millet's Sheikh Abdullah's statement to the Constituent Assembly on 11th August. I crave permission to make a statement before the House in regard to the constitutional relationship with Jammu Kashmir and the Indian Union. As the honorable members are aware, during the last session of the Constituent Assembly, the Basic Principles Committee had submitted a report making certain specific recommendations about the future head of the state. House, while accepting these recommendations, had charged the drafting committee to present for the consideration of the Assembly a draft resolution incorporating the proposed principles for the election of the head of state. Drafting committee will no doubt submit its report to the House. Since the changes proposed in the Assembly involve corresponding adjustments in the Indian Constitution, Government of India desired that it should have time to discuss with our representatives other matters pertaining to the constitutional relationship of our state with the Union. During the last stage of these discussions, it became necessary for me and some of my other colleagues in the government to participate in the talks. I'm now in a position to inform the House that certain broad principles have been laid down and certain decisions have been tentatively arrived at between the two governments. The basis of our relationship with India is the instrument of accession, which enabled our state to enter into a union with India. In accordance with the terms of the instrument, certain powers were transferred to the center. The principal matters specified to the purpose in respect to which the Dominion legislature could make laws for the state were. This arrangement involved a division of sovereignty, which is the normal feature of a federation. Beyond the powers transferred to it to the Union, the state enjoyed complete residuary sovereignty. That's why, Mullahs, when you read 370, you can't read into it, Mullahs, other matters. These terms of the association of our state with the Dominion were maintained, and subsequently when the Constituent Assembly of India was charged with the task of framing a constitution, this overriding consideration was kept in view in determining the position of the state in the proposed constitution. Earlier to this, it had been agreed between the two governments that in view of the special problems arising in respect of the state and the fact that the government of India have assured its people they would themselves finally determine their political future, a special position should be accorded to Jammu and Kashmir in the future constitution, so that a limited field of the union powers over the state is ensured. Our representatives were nominated by the Jammu and Kashmir state to the Constituent Assembly of India. These representatives participated in the deliberations of the Assembly in India at a time when the bulk of the Indian Constitution had already been adopted. It was at this stage that the constitutional position of this state was determined in the Constitution of India. This is very important. It was in a collaborative exercise, a dialogue. It was not behind the back of the Union of India or anything like that. They knew what was to happen in the future. Representatives of Jammu and Kashmir reiterated their view that our association with India should be based on the terms of the instrument of accession. It was at this stage that the constitutional position was determined. The representatives of the Jammu and Kashmir state reiterated their view that our association with India should be based on the terms of the instrument of accession. It was also made clear that while the accession of Jammu and Kashmir state with India was complete, in fact, and law, to the extent of the subjects enumerated in this instrument, the autonomy of the state with regard to all other subjects outside the ambit of the instrument of accession should be preserved. Evince a good deal of confused thinking and uninformed criticism is indulged in some interested people. I would like to point out that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with a proviso that they may be extended to such other matters as the President may by order specify with the concurrence of the Jammu and Kashmir Assembly. This is the concurrent list matters. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of India, of the Indian Union, therefore clearly envisaged the convening of a Constituent Assembly for the Jammu and Kashmir state, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. That's why temporal. But the rest really need not trouble your lordships. I need not trouble your lordships. Then, but as rigidity powers, it's important. Page 19, PDF 19. There is a heading of rigidity powers. It was agreed that while under the present Indian Constitution, the rigidity powers vested in the center in respect of all the states other than Jammu and Kashmir, in the case of our state, they vested in the state itself. This position is compatible with Article 370 of the Constitution of India and the instrument of accession on which this article is based. We've always held that the ultimate source of sovereignty resides in the people. It is therefore from the people that all powers can flow. Under these circumstances, it is up to the people of Kashmir through this assembly to transfer more powers of mutual advantage to the custody of the Union. So, but what happens ultimately, and I'm just, since I will come to that later, is that Parliament exercised the will of the people of Jammu and Kashmir when they abrogated the article. That's what happened. They took upon themselves the constitutional responsibility of saying that we are now the legislature. We are the Constituent Assembly. And we will exercise the will of the people of state of Jammu and Kashmir to say that we abrogate 370. In essence, that's what happened. Is that possible constitutionally? Is that envisaged by 370? Is this not an exercise of political power? Without reference to 370? And can such a power be exercised in the manner in which it was exercised? That's a matter of procedure.